I'm going to have to duck out in about 10 minutes to 2 and take care of that. The chief is going to take over to preside if we're not done, and we probably won't be. All right. This meeting is being recorded. The next item, number 8 on the agenda, procedures to compel a ruling. And I understand Bill Boyce will lead us through the thicket of this issue.
Yes, thank you, Chip.
Sure.
So we are revisiting a topic that we had discussed. I don't think we reached it at the last meeting, but we discussed it at the meeting before. And I'll go through the genesis of this briefly because what the memo for today's meeting does is present 2 options to address the issue. And there's not really consensus on the subcommittee about which one to follow, or maybe there is, and I'm not grasping it, but I will go through that here shortly. So by way of background, this initially came as a referral from I'm sorry, I'm having a telephone issue here. Okay. From Justice Gray that started out as a question about efforts by pro se prisoner litigants to get rulings that would enable mandamus. We talked about it. It was sort of expanded to cover a recognition that there are civil issues as well where it's difficult to obtain a ruling, and what are the procedures for doing that. We received subsequent guidance from the high courts that we should really focus on the civil aspect of circumstances to try to obtain a ruling. If you filed something, but you can't necessarily establish that it has been seen or received by the trial court and just not ruled on, you can be stuck in limbo for a period of time trying to get a ruling on something. So we talked about basically 2 different approaches to addressing this issue. One is creating a presumed notice or presumed denial mechanism under the rules of civil procedures that would basically allow a notice or a request to be filed, and after a set period of time, it would be presumed that the trial court received and was aware of it for purposes of seeking mandamus relief solely for purposes of obtaining a ruling. That's alternative number 2 that's contained on page 4. The other approach, which is one that was developed in the most recent subcommittee discussions, was more of an administrative reporting approach, focusing on a proposed addition to Texas Rule of Judicial Administration 6 that would get at the same issue in a different way by basically requiring judges to keep up with reporting requirements that would apprise them of things that had not been ruled on. And I'm happy to launch into discussions of these approaches further, but at this juncture, it may be appropriate to ask Judge Peoples or Kennan, who were particular proponents of an administrative reporting approach to describe more fully their thought process and why they think that's a good way to go for this issue.
Thanks, Bill. Judge Peoples has already volunteered to share with us his views, and of course, if Kenan has views, we'd love to hear those too, but we'll recognize Judge Peoples first.
There are existing rules in Administrative Rule 6 enacted by the Supreme Court back when Tom Phillips was Chief Justice, which is called Time Standards for Disposition of Cases. But it's all about people supervising others. There are no real teeth in it, and proposed subsection E, I think, would add some kind of enforcement mechanism, sort of. The problem is not widespread. I don't think this is a widespread problem, but it is very serious when it happens because it's a failure of judicial duty. It applies only to judges who have matters that are submitted and waiting for a decision more than 90 days. Not one judge in the state has to report, under this proposal, would have to report anything if he or she is current and doesn't have anything awaiting decision for 90 days or more. It doesn't apply to things that are simply filed but haven't been heard yet. It applies only to matters that have been submitted. The judge is not waiting for anything. Everybody's waiting for the judge to make a decision, which is what we're supposed to do when we hold this office. And so E would add a reporting requirement for judges. And one question would be to whom that has to be sent. And we have three choices. You use all three of them. The Office of Court Administration, or the local administrative judge, or the regional presiding judge, or some combination of those, maybe all three. There's no express sanction for someone who doesn't do this, but it is, there's language in the proposed subsection E, which points out this would be a duty of the office, and I myself think that would enable the Judicial Conduct Commission to get involved if somebody does this and it's bad enough. So, and another thing that's sort of unspoken but in the background is the feeling, I feel this way, and an awful lot of people feel, that lawyers shouldn't have to poke the bear or stir up the hornet's nest by reminding a judge, Your Honor, you've had this for 3 months or 4 or 5. I know of a case in a medium-sized county where the jury came in with a verdict 2 years ago, and there's some question about what kind of judgment should be rendered on that verdict or whether a new trial ought to be granted, and the judge has not done one thing for 2 years. I had a recusal motion a good many years ago in which I learned in the motion that the judge in the very case had a pending motion to transfer venue in a family law case that he'd had for 22 months. 22 months. And it's mandamusable after 6, but he hadn't decided it for 22 months. And I was surprised in the previous discussion we had in the full committee, both informally and on the record, of how many people had their own anecdotal experiences with judges who've got the briefs, got the arguments, and simply cannot make a decision for a good long time. And I was just surprised and flabbergasted, actually, that so many people have experiences where judges have just not ruled. So proposed E, and that's alternative 1, it aims to get at that. And then alternative 2 really speaks more to Tom Gray's issue, which was the mandamus petitions they get from prisoners who have filed something and the judge hasn't even dignified it by looking at it, apparently, much less ruling on it. And so these two proposals sort of come at it from different ways, and that's what is before the committee.
Kenan, anything you want to add?
I don't think there's anything I could say that would be better than what Judge Peoples has said, so I will stay silent.
Okay. Comments, Commissioner Sullivan.
Just a quick question. I'm curious about the administration of a reporting rule. And in particular, the extent to which we would have confidence that every county could uniformly run a report that would yield information as to what judges have matters that have been pending for 90 days with no ruling. Could we get statewide compliance with that, county by county, and that sort of reporting where it's coming essentially from the clerk's office, it would avoid the need for self-reporting, which, has some obvious issues associated with it. Just curious if anybody could answer that question.
Judge Esteves?
Hold on. Well, I don't believe you need reporting after 90 days. I think there's several reasons sometimes why things don't get ruled on, and sometimes the parties are still going on. And you had your initial hearing, and there's just too many complicated reasons why things don't get ruled on after 90 days. My understanding of why we started this had to do with Justice Gray and the issues with our inmates. And I'll tell you that I review those motions. Sometimes I get orders without even a motion pending. Nobody responds to the other side. Nobody ever sets it for hearing. And I know under this isn't even triggered, but the next thing they do file a mandamus. And so I either was unaware of it or something may have happened along the way. There definitely wasn't ever a hearing. So I think one of your proposals had to do with a denial as a matter of law after a certain period of time. I don't have a problem with that because I think all the parties would be very interested in pushing a ruling that way, explaining to the judge that in 2 more days, it's going to be a denial in case the judge just, for whatever reason, was waiting on one final thing. But I don't believe the reporting is going to be helpful. I think it's going to require more from the OCA, and are you really going to have something set up for grievances and things like that for a judge when they may have legitimate reasons why they haven't ruled or just been unaware of it? And then do you really have to spend all that extra time to respond to a 90-day or 91-day ruling or a 100-day ruling? I think it's just too much. So that's I like the idea of in any type of inmate case, if you need to expand it, but if you limited it to inmate cases, I think that is the problem. Sometimes we get those motions and we don't even understand them.
Robert Levy.
I have the delight of serving in a prison county. So I get there's a big chunk of litigation that I get regarding the inmate case.
So I have a few comments. One is I don't see these two proposed rules as alternatives. I think they can both work together. I believe that in the federal courts, they have this type of reporting where they will report on judges who have motions that are pending. I think it's 6 months. Judges are somewhat accountable for that. And I think that it would be an appropriate measure of the administration of justice, not only how many cases are pending, but how many have issues that have been presented. In some situations, I think like historically in Harris County, you could file a motion and a response is filed, and unless it's set for submission or set for hearing, it will just sit there. So it might be a little bit unclear as to when that clock should start running. But another question is, the issue that was raised about in some cases, it might be better to simply have the motion overruled by operation of law, similar to, I think, a motion for new trial, that if you don't rule on it by a specific point in time, then it's denied. I realize that won't work for some types of motions, but In that case, you get that resolution, and that then gives you the ability to submit a mandamus, so that if you submit a notice that a ruling is needed and there's no disposition by a set period of time, then it's just denied, and then you can move forward with mandamus relief if appropriate, or it might just allow you to proceed with a straightforward appeal. I do think that this rule, the approach makes sense.
Thank you. Roger?
I guess as much as I don't like poking the bear, and I maybe think it's a good idea that you have an administrative 90-day report. I have seen in the federal court the slowpoke yearly report about how many judges have motions pending over so many months. But here's the thing. They have a very efficient clerk system and usually a procedure in place that your motion is deemed submitted after a period of time. And I am sure the judge is made aware that it's pending, the federal judge, I mean. The other thing is, every time anything is filed, if it's a motion, it gets a number, and the date to respond to it is calculated by the clerk for you, as a matter of fact, and you can see it on the docket sheet. And I think in order to make a system where the administrative rule sort of creates this 90-day slowpoke report, it is going to put a big burden on the trial on district clerks and county clerks to figure out, is this a motion that's been filed or not? Has it been set? When did it get under submission? That's a lot to ask from some clerks, especially given the high volume of civil litigation in some districts. So I guess I tend to lean towards some sort of notice, even if it means poking the bear. That's my opinion.
All righty. Lisa Hobbs?
So I want to answer Commissioner Sullivan's direct question based on my knowledge of reporting ability. Whatever, it's been more than a decade since I left the court, even though I look so young. Like, how could it be that long? But they are on a county by county basis. Judges don't typically do the report themselves, as I understand it. It's county reports. I'm not sure whether it's the clerk that does it or somebody else, but I don't think at this point, absent particular courts, like maybe MDLs are done differently, I don't know, but just in general, I don't think it's a judge making the report. I think it's a county report that I presume comes from the county clerk and or the district clerk. So you've raised a valid point about just how it interplays into the current reporting system. That said, I do think there is value in reporting, even if there's non-compliant reporting, like and a reporting requirement. And we've addressed on the slowpoke report in the federal courts. And I do think you start to, once that deadline starts coming up, you do see federal courts sort of like, we got to get this case off this, so it's not on the slowpoke report. What's clerk, what's pending, what's, you just do some assessments internally of your docket when you know something is going to be about to come up. But as has already been said, they also have a lot more support than some of our county and district judges. So internally, they probably know when those cases are due easier than our state court judges do. But just from experience, I remember when the legislature required the Chief Justice of the Texas Supreme Court to report on who was missing internal deadlines, which I think they still do. I don't know. I haven't looked at that rider in the budget. We don't do that anymore. Okay. Justice X saying no. But when they first came out with it, it was highly effective because no one wanted to be reported that they were missing internal deadlines. So I just saw from firsthand experience that sometimes reporting deadlines, even if there's no remedy for curing it, just we're dealing with elected officials who don't want people to think that they're not doing their job and they're not doing their job as efficiently as they can. So there's value in reporting. I'm a little bit nervous about ruling any rule that would say something is granted or denied as a matter of law after a certain time frame. We have that certainly with the motion for new trial. The Texas Supreme Court has that on a motion for rehearing after 180 days. I still believe that's the rule, but it's just, it doesn't serve justice, and it can have unintended consequences. And the motion for new trial stage, they become formulaic. Like you could have super valid grounds for seeking a motion for rehearing. I mean, a motion for new trial, and you can't get it set. It just becomes this preservation document that has like kind of no meaning. And I just worry about extending that idea to other motions that might be more important. And I've gone up on mandamus for a failure to rule. You can do it even if that is a valid ground. If at some point it becomes really unreasonable, I think you can take it up and get at least temporary relief to make a ruling when it's, something important enough that actually, is affecting the way that litigation is going. So those are just, I'm sorry, that's a little snapshot. I was just taking notes as everyone was talking, so I'll shut up now.
All right, Bill Boyce.
Yeah, I wanted to respond to Robert's point about having a automatic overruling as X number of days, to underscore the same point that Lisa made, which is I think that there was heartburn on the subcommittee about rights being lost by folks who didn't know for various reasons that something had happened or what they needed to do, or that something would get overruled automatically. And so the second proposal on the last page of the memo that you see was drafted more narrowly to just create a presumption of notice rather than an overruling of something on the merits.
Okay. Richard.
Thank you, Chip. I think there's some important value to having a public record of judges who don't rule reasonably quickly, especially if it's a chronic condition, and especially with the elected judiciary, but even if we do go to an appointed judiciary. So I greatly favor a report that's available to the public and also to opponents who are looking for grounds to unseat an incumbent. So I think that the public reporting is good. I agree with the idea that it's very difficult for a clerk with thousands of filings to know when a ruling has been under submission for more than a certain period of time. So I'm attracted to the solution we use on findings of fact and conclusions of law. Under Rule 296, after a bench trial, you can request written findings and conclusions, and then they're due within a certain period of time. And then you file a reminder, and then the deadline is extended. We could invent a process called a certificate or a reminder of need to rule on a case or something like that and say, if a matter has been under submission for 90 days, a party can file a reminder, and we'll make up the title so that it's pretty clear what it means. And then all the clerks have to look for is the reminders. They don't have to look for motions and figure out when it was heard and how long it's been since it was heard. The clerks can just look for these reminders. And I wouldn't suggest that failure to file a reminder should be a waiver of any right. I'm just saying that the lawyers are the ones who are watching the clock. They can file the reminder. The clerk can look for the reminder, and the reminder will be the trigger for the reporting. With regard to the issue of automatic granting or denial of a motion, I agree that I hate for people's substantive rights to be either affirmed or rejected by operation of law without the intervention of a judge. After you've had a hearing and paid lawyers and done briefing, it seems to me like you're entitled to a ruling on the merits. As an alternative, we could have a provision that if a reminder is filed and the court fails to rule, and let's give a fixed deadline like 15 days or something like that, that it will be grounds for mandamus. And that way, no one's rights are prejudiced by a ruling or a denial, a grant, or anything else. But we're sending a signal to the judges that if you get this reminder, you've got so many days to rule, or else they're going to get a mandamus against you. And then the courts of appeals need to put some muscle into it by granting mandamuses. So I think my suggestions are kind of practical approaches, is let the clerks look for the reminders, and let's let the appellate courts, let the trial courts be on notice that if they wait too long, they're going to get mandamus. Thank you.
Thanks, Richard. Commissioner Sullivan.
I think Richard's idea is intriguing. Certainly worth some thought. I just want to circle back to the fact that I assume that the federal court report is the analog that we're using here. And I think the important consideration that I was trying to point to earlier is the fact that the federal courts clearly have the administrative infrastructure to support that uniform reporting system. And I'm curious, and maybe if I could, I'll direct this question to Judge Peoples, is I was wondering whether this proposal, which reads to some extent like a self-reporting system, if I'm reading it correctly, talks about the judge sends an explanation for anything that's hadn't been ruled on in 90 days. Is that the essence of the proposal? What would in effect be self-reporting, or was it the contemplation that there be independent reporting from the clerk's office of anything that's been pending for 90 days? And then the separate question, I'm just curious because you've got the experience to give us, I think, a good estimate of the system. Do you think that we have the infrastructure that would allow for uniform county by county reporting of these sorts of matters if we went that direction?
Thanks for the question, Kent. I'm kind of baffled at all this talk about clerks having a duty on this. It seems to me when a judge has tried a case or has a summary judgment motion under advisement, either after an oral hearing or not, the judge ought to remember that. And if a judge has so many of these that he or she can't remember them, then that means it's a real big problem that needs to be addressed. I'll say, in all my years, I never had a single thing anywhere near 90 days waiting for a decision. And I think the vast majority of judges don't. So I just don't think clerks would need to be involved in this at all, because it's something that the judge ought to know in the back of his or her mind. I need to do this. And gosh, I need to find time to do it. And if I can't do it, I'll have a reason, shouldn't I? I mean, I ought to be able to say I've been tied up in capital murder jury selection for 3 months, or whatever the reason is, if there is a reason.
Chip.
So I just think the burden on clerks, or how clerks are going to do this, I don't see it that way. And that certainly is not the intent.
Got it. Somebody was trying to.
Yeah, it's Stephen
Yellenowski. Line here. Who was that?
Yeah, it's Stephen Yellenowski.
Yeah, go ahead. There's a bunch of people in line, but go ahead, Stephen.
Well, I didn't see any other hands up, so I figured I'd jump in. If somebody was ahead of me, go ahead.
All right, well, Justice Christopher, somebody no less prestigious than Justice Christopher was ahead of you.
Go ahead, Stephen. I'll go after you.
Sorry, I didn't see a hand there, so I thought Chip maybe just didn't see it. Just some observations. One, no, the clerks don't have the infrastructure. Two, if they did have the infrastructure, you're creating a situation in which an elected clerk is in a position of chastising an elected judge, essentially, perhaps in an election year. I don't think that's a good idea. It's a bad idea for the judge not to do things in a timely manner, but it really puts the clerk in an odd situation in continued relationships with the bad judge who won't rule. If it's not automatic, then is it going to be used? Right now, lawyers could file mandamus, but this is the first time I've heard of lawyers actually doing that. Maybe it's one time you're in court, but lawyers who are in the same court a number of times are not going to poke the bear. So that's the second point. I don't see how it works if it's not automatic. And if it's denied by operation of law, I am concerned about makes it too easy for the judge to punt. And again, since we're talking about judges who don't rule in a timely manner, Judge Peoples said they should do this, they should do that, and they should, but some don't. That's why there's a problem. And those same judges, if there's an automatic or operation of law, denied by operation of law, may find it easy to just punt. No, I didn't deny it. It was denied by operation of law. And finally, none of this so far is going to address the problem with prisoners. In my experience, it's very hard for prisoners to even get attention when they file things, much less get something before the court that a lawyer or even a pro se litigant who's not in jail could. So whatever of all the things being considered right now, I haven't heard anything that requires a judge who's inclined to dismiss without consideration prisoner complaints or prisoner suits, any way of addressing that. And finally, nobody's talked about the local presiding judge perhaps having a role in this.
Thanks, Stephen. Now, Justice Christopher.
Well, when I was a trial court judge in Harris County, I would on average have 30 motions set for submission on Monday morning per week. And then I would have probably another 20 set for oral hearing on Monday. So Judge Peoples, it's easy to lose track of the fact that you haven't ruled on something. And sometimes the summary judgments are this big, this big. And now that everything's electronic, once again, it's easy to lose track of something. So I definitely don't think that a judge would be good at keeping track of what things were over 90 days. We have had a situation in Harris County and we've issued maybe 5 mandamus opinions against the same judge for failure to rule. But it's a pretty few and far between problem. And issuing the mandamus opinion is not really working well either, because it hasn't made that judge change the judge's actions. Because the judge will rule, then get behind, won't rule, get behind, won't rule. To me, the key is the regional presiding judge who could get in there and talk to the judge and take cases away from the judge. Because that ultimately is what needs to be done, right? Not automatically denying something. Get the case transferred to somebody who's going to pay attention to it and rule on it. I mean, automatically denying a summary judgment, that doesn't help people. If it's a judge who hasn't ruled on entry of judgment in 2 years, you can't do an automatic denial of that. Automatically denying a request for discovery, that's not good. What you need is administratively, and I think it has to be the regional presiding judge. And the reason why I think that is that person is generally not up for election. Now, I think we have, like Anna is, but a lot of our regional presiding judges are retired now, right? And no longer up for election. So they are in a position to actually go to the trial judge and say, you're not getting your work done. I'm taking cases away from you. The local administrative judge is also up for election. And it's difficult. I mean, this one particular judge, we notified everybody. We notified the Court of Appeals did. We notified the local administrative judge. We notified the presiding judge. We notified Harris County's internal lawyers, right? They have certain lawyers that help the judges on things to try and get the judge to move forward. To me, when you have that kind of a situation where it's a systemic problem, the only way to take care of it is through moving the cases from the judge. And if it's just oh, I forgot, and you file the mandamus, people rule. And because we see that, we'll file the mandamus, we'll say, okay, let's have a response. And the next thing we know, the judge rules. So apparently Harris County is a big enough county that people are doing it. Maybe unlike Austin, unlike a smaller county.
Can I ask a quick question, Tracy?
Yeah.
How would the regional presiding judge know that Judge A has a bunch of unsubmitted matters if there's no duty to report?
Well, the regional presiding judge knows because someone has filed a mandamus, and we send the mandamus to the regional presiding judge. I think that we got to rely on the lawyers to want to move their case. I mean, Judge Estevez is exactly right. You get, at least in Harris County, and I'm sure it's true in many other counties, I don't see a motion unless it's properly set, right? So it either has to be properly set for submission or it has to be properly set for hearing. I do not see every piece of paper that that got filed in a case. I mean, we have 1,500 civil cases on the criminal side. They'll have, on the federal side, they'll have 100 civil cases, maybe 150. I mean, the volume that we have, you can't really look at what the federal courts do versus what we do. And in county courts, it's even higher in terms of the volume of the cases that you have on your docket. To me, you got to wait for the lawyers to really want a ruling. I don't mind this second proposal, this request for a ruling. But so what happens when the pro se, who never said it right to begin with, sends in this notice of ruling, right? Or what happens with motions that are filed after I've clearly lost jurisdiction, right? That just gets put in a file, right? Never seen by the judge. And then the next thing you know is you get a, notice of ruling that is some sort of prima facie evidence that I should be mandamused. I mean, there's just all sorts of problems with both of these things.
Bill Boyce.
So I hear differing views, and I think moving forward would be aided by a vote on Do we do one or the other approach or both?
Okay,
Chip,
yeah, yes.
this is Munzinger. Let me share a thought I have here. In state court, I don't know how a district or county clerk ever knows that a motion which has been submitted to a judge has been pending for any period of time after it has been submitted. Because there is no, to my knowledge, procedure where one or the other party or even the court files a document, does anything of record to indicate that a motion has been submitted and is now awaiting decision. We don't have that. Federal courts have all kinds of things, but we don't have that in state court. How can you have a reporting by a clerk who doesn't know that a motion has been submitted? I don't see how that happens. You might want to suggest a procedure where any party to a motion may file a notice of submission or something along those lines that the motion has been submitted. And if there's no objection to it within 90 days or whatever time period you want, any party may seek mandamus relief, and that's a ground for mandamus. That doesn't mean anybody's going to. I've been victimized this way 3 times in my life. All 3 times the client told me let it pend because nobody wants to poke the bear, as you say. But in any event, I don't know how the clerks would file a report because they don't know when a motion has been submitted. They know it's been filed, but they don't know if it's been briefed. They don't know any of that stuff. So I don't see how you could have a clerk have any kind of an automatic duty to report without something else being filed by one of the parties. And I join the chorus of those who oppose any automatic ruling that could prejudice a client because of a failure of a judge. I'm finished. Thank you.
Thank you. Robert Levy, and then after Robert, I'm going to drop off and hand this off to the chief, who will continue moderating this discussion while I go visit with Judge Mazant, and I will be back as soon as I can. But Robert, you're next, and then Frank.
Thank you. I wanted to go back to the question about the alternative 2, and it seems to create additional, in effect, mandamus jurisdiction for the courts of appeal. And it would seem that this will potentially flood courts of appeal with mandamus petitions that will require at least a lot of process. And in the pro se cases, I think that will just be grist for the mill for them. And in the situation with a case where you've got a motion that hasn't been ruled on, you're then forced to go to the expense of filing the mandamus, asking the Court of Appeals to make a decision, to force the trial judge to rule. So the merits of the issue aren't going to be addressed. You're going to end up delaying the process for weeks or months. And obviously, most of the time, the Court of Appeals will withhold the mandamus and just suggest to the trial court you need to rule. But then, of course, you have to deal with the merits of the issue. I think that Richard Orsinger's idea of like a process to notify, but then that itself is actionable and will either accomplish what I had suggested, an automatic determination. But in addressing Judge Boyce's comments, I'm not suggesting that a party would automatically lose their rights due to the operation of this rule. My thought is that it would require a party to actually file that motion or that notice of a ruling needed to trigger the process and then let the case go forward so that it doesn't get stalled out or significantly delayed by a mandamus.
Frank Gilstrap.
We started out with what seemed to be a simple problem, namely the prisoner cases, and we've expanded it into a much more complicated problem involving the whole judicial process. And it is a meritorious problem, and I appreciate all of the thoughts about this, but maybe we need to eat the elephant one bite at a time. Prisoner cases are a specific kind of cases. They're even recognized in law. And there's a problem there because they're incarcerated. They can't go to the courthouse and see what's going on with their case. So why don't we start out and eat the elephant one bite at a time? Why don't we pass an automatic denial rule and limit it to prisoner cases? If we're going to go on and expand it to other type rulings, I think again we need to eat the elephant one bite at a time. It's one thing where a judge has had a jury case tried and hasn't ruled on it, but it's a completely different case where an experienced judge is carrying a motion for summary judgment to trial. And I've seen that used quite well to advance litigation. Finally, if we're going to talk about a requirement to rule, we already have requirements to rule. Rule 91A, the Citizens Participation Act. There are other provisions as well where the courts of the rules say that you have to rule. Are we going to overlay this with some type of rule that applies to all cases where we require ruling in every kind of case? I just think that's a bridge too far. Let's start with a simple case. Thanks.
Alistair Dawson.
So in my experience, this is a fairly isolated issue where you have judges that either don't want to or refuse to rule. I don't remember a specific case where I've ever had a problem with it. And I fear that we are either creating unnecessary work for a lot of judges who are doing their best to rule, and or creating more mandamus, which I don't think our courts of appeals need any more mandamus filings. Most of the time, like I'll give you a recent example. So we had a discovery hearing or discovery motion that we were required to file under submission because of COVID, because the courthouse wasn't open, and we did. And as Justice Christopher pointed out, it kind of slipped through the cracks, and we needed a ruling before some depositions. So I just told the court clerk I need a status conference to raise an issue with the judge having to do with an upcoming deposition. And we got an oral hearing, and we had our ruling, and he issued our ruling, and the case moved on. I am actually persuaded that we, rather than having all this alternative one or alternative two, why not create a mechanism whereby a litigant who hasn't gotten a ruling, feels like he or she is entitled to a ruling, their case is being jeopardized, can file a motion with the regional presiding judge to have the case transferred to another judge. Sort of follow along Justice Christopher's suggestion of let the regional presiding judge address the issue, but maybe he or she talks to the judge, see if they can figure out a resolution. And as Justice Christopher points out, we do have one judge in Houston that's known for not ruling, and if regional presiding judge thinks that that's going to be a pervasive problem, then he or she can transfer the case to another court. It also has the advantage of hopefully reducing the number of mandamus filings. So that's my suggestion.
Jim Perdue.
Thank you, Chief. So this is an issue that's got some odd constituencies because I think I'm hearing a little bit of a course that I wanted to come in on. Mandamus as the remedy for this is a dangerous slide. I know my friends who are appellate specialists love mandamus. I think mandamus is available if you can't get a ruling, especially like a judgment. And so when I read this rule again, I was trying to figure out how it would invoke the right to mandamus any more than already exists, because I don't read the language in the proposed rule as necessarily giving you a per se right to mandamus. And I agree wholeheartedly with Alistair that the idea of taking up the failure to rule on a motion to compel or a motion for protection is an even greater slide into mandamus practice than where we are. The only thing I wanted to add then is I don't know about regional administrative judges' ability to rectify what I agree with Alistair is a pretty small problem. But that solution does seem to find some compromise to what Judge Peoples has done with this reporting question, which I agree with the commissioner has an IT element to it that I'm not sure that capacity exists within our budget, but you can see how it federalizes a little bit of this reporting practice, but maybe if you had the empowerment to transfer or take away the case, you'd get a remedy that would bypass and find some middle ground between these two proposals. The last thing is, I think this has been the majority voice, so it doesn't need mine. Denial by an operation of law is incongruent with what the real issue is here. And if you're looking for a final judgment on a verdict that's 100 days old, that you can't deny that by operation of law. You've got to get a judgment. If you've got competing motions to compel versus motions for protection, you can't deny both. It's not a binary situation with those examples. So while that denial by operation of law exists in very specific questions, I don't see how you could take that and put that into this situation. So just from my little old perspective, agreeing with a lot was said and throw it in for the hopper.
Levi Benton.
Let me respond to a number of things. First, I think it was Richard Munsinger who made the observation that the clerks might not know that something had been pending. I think every time a court sits on the bench to consider arguments, there's going to be a clerk in the courtroom. So the clerks are able to note in the file real time what, in fact does note, did the judge take it under consideration? Did the judge say, matter is submitted, taken under an advisement? So there's always a calendar entry that the clerks can make. And of course, the clerks have some control over the submission docket. And so I don't want to exclude the clerks from the process if we're going to have a process, because they are in fact in control of the calendar. I want to add my voice to those who observe this is not, I don't think this is a huge problem. I'd never heard of it being a problem until recent issues out of Tracy's court that they had to address. But no one has really talked about what's the remedy by way of mandamus other than to take the case from the judge. The Tracy's court can order a judge to rule, but what if the judge still doesn't rule? Then what? I would like to offer, instead of taking the case from the judge, whether it's the regional judge or the Court of Appeals should order that the offending judge should get no more new cases assigned to such judge until the issue's cured. And then I really like Gilstrap's idea of one bite at a time. Maybe we really just address the prison cases first and see how that works out, and see if there's a real problem with other cases outside of the prison cases or prisoner cases. That's all I've got, Chief. Thank you.
Yep. Bill, back to you, and then Presiding Judge Estevez and Presiding Judge Evans.
So I heard some sentiment for take on the prisoner cases first, which was actually the genesis of Chief Justice Gray's letter that led to the referral in the first place. The guidance that we got from the courts, from the two high courts, was to focus on the civil side rather than the criminal side. And so if there's sentiment from the committee as a whole to take another look at the prisoner cases, I guess we can present that to the courts, and the courts can decide if we should move forward with that. But I just want to highlight that because this started out with respect to the prisoner cases, it expanded into the civil cases, and then it focused on the civil cases, and there's some desire to go back to the criminal cases, the prisoner cases. So we just need to, probably the subcommittee would need guidance if that's the direction we're going to go. And I also wanted to address the point I think Jim Perdue had made in terms of encouraging more mandamus. Really, I think the concern, and Chief Justice Gray may have thoughts that he wants to articulate it if I don't get this captured properly. But the point was that the mandamuses were being filed anyway, but they were being summarily denied because of an absence of proof that the trial court had actually received and or considered and or not acted on a request for relief. And so to avoid that unproductive exercise, that was the genesis for a rule proposal in the first place that said, if we come up with a procedure, you can at least have it established that something has been brought to the trial court's attention and not ruled on for purposes of just the narrow effort to get a ruling on something separate from the merits. So we're kind of circling back on some topics that began at the beginning of the process, and so I think the subcommittee would benefit from some guidance about going a particular direction, because there's a lot of good ideas. There's pros and cons for all these approaches, and I think some guidance from the committee as a whole would help to frame something for the next round, the next presentation.
Presiding Judge Esteves.
First of all, I'm going to go ahead and clarify some jargon that we are using because I didn't realize that it may be unclear. An inmate case is only civil cases. So it's a civil case that a inmate that's in prison has filed against the prison or some other entity, but they want to be heard while they're still a prisoner. So they filed this lawsuit while they're an inmate in prison, not in jail. They're serving a sentence. They're usually there for, in my experience, 20 to 40 year sentences. So I don't have like a practical way to get everything done in person. So they're only civil cases when that's what Justice Gray was bringing up with these inmate cases. I would like to hear from Justice Gray and any other Court of Appeals justice, because I will say that I don't know how many mandamuses I've had filed against me over the last 14 years, but I will say for a lack of a ruling, they have only come from inmates. And in every one of those cases, I never had noticed that a mandamus had been filed or even that this motion may have been pending. And so usually what would happen was the first time I heard about it, I got this, please respond. And then I said, respond to what? And I look at the file and then I either then ruled at that point, and I would say I probably denied the motion 100% of the time because it wasn't anything that was something I could do or something that may have needed a hearing or wherever it was. But I would suggest that the problem is not large enough that you need to address it in any other area except in the inmate cases, just because it's a common thing for them to do. They'll file something, we never get noticed. You don't get notice of anything in my jurisdiction unless there's a proposed order, and then they rarely ever try to set it for hearing. They don't request a hearing. Different things happen. I can't even discuss all of the ways that they don't do it correctly or don't do it in a way that would trigger any type of response. And sometimes it may be just unilateral, nobody needs to respond, but I wasn't even aware of the filing. And I do believe that the best way to deal with the inmate cases is go ahead and have that 90-day denial, and then they can appeal it, or as it goes on, we can address it at another time. We can reconsider it, not even knowing about it, or whatever, when the case continues to go. But we need a solution for that. And I'm going to agree with Justice Gray. This is a huge problem, because I would have rather have ruled on that motion than had to go off and then file a response, because I still had to file my response. My response was, I've just ruled on it. I wasn't aware of it, or whatever it may have been. But, all of a sudden it was the same thing as the trigger of the notice would have done. I have never had a mandamus from a party in a regular civil case that wasn't an inmate suit. And what happens if I forget, or for some reason it slipped through the tracks? They call my court coordinator. My court coordinator sends me a email and says, have you ruled on this or calling on this? And I look at it and I determine why I haven't ruled on it, or if I didn't have a reason to not have ruled, I might ask for additional briefing. I may at that point rule on it one way or the other, but I always act on it once somebody has brought it to my attention. But I don't think that is, I think that's a common thing that happens, and that's how most people address it, except for Ms. Hobbs, which is fine. I mean, if I got it, if she had done that, she probably did that several times and nothing happened. But I would suggest that 90% of the judges with that kind of, hey, have you ruled on this? Hey, are you going to rule on this? They eventually end up ruling on it or asking for additional information if something's holding them up. Judge Benton had said something about there's a clerk in the courtroom. Well, there's not a clerk in my courtroom or any of the judges I know. So you were the first time, and maybe it's just in Houston, but I had no idea there were clerks in the courtrooms in other states or other, counties. And then, if we went forward with the notice, how do I find out about the notice? I mean, so I don't know about anything that's filed. I know when I go to my hearing, or I have something that's been set for submission, and I get that from my court coordinator. But all the other filings, I have no idea what's been filed every day. And so if I get that notice, when are they sending me that? So all of a sudden, if I was Justice Christopher, because I have it set up different, and I was a trial judge at in her time, and she did 50, let's say she did 50 hearings that day, because it sounded like she had 30 and then she had 20. So she had 50 of them. So does that mean a week later she gets a notice and she gets 50 notices and they're all on her computer, and now she's overwhelmed because she's just heard 50 more, and then she goes to the next one? I mean, I think that's overwhelming. I think it sounds like a nightmare, and I don't think that the judges are doing as poorly as that. I think that there are cases that are a little more difficult that judges do sit on, and they're looking for some divine revelation that may never come. But if you prod them with those emails, I think most of the time you'll get a ruling, and you'll get a timely one.
Presiding Judge Evans.
Thank you, Chief. It sounds like another pandemic from a regional judge's point of view, as a number of duties that might be assigned as a result of this problem. But a couple of comments. Justice Christopher makes a point about regional judge adjusting caseload of a judge who's not getting their work done. I think we need to look carefully at the government code. I think that's still with the LAJ, but there's another way to approach it. If I think her point is well taken about the regional judge having some distance and being used to ruling on matters where colleagues might be offended. I would say that transferring whole loads to other industrious colleagues is going to meet with a lot of backlash, because they'll tell you you're rewarding the lazy and punishing the industrious. So I would like you to look at that. But what I think Justice Christopher has really said is it's a de facto ground of recusal. And if you want to make it a de facto ground, if you want to make it an in fact ground of recusal in a case for failure to rule, then you should build in a notice that you haven't ruled, probably a second notice that you haven't ruled. And then if it's filed, the presiding judge recuses. And I will tell you that as a trial judge and as someone who works with trial judges every day over recusals, no one likes an adverse ruling on a recusal. It's in the file, it's public, and the grounds which were alleged are known. So if you want to look for something that has, for Richard Orsinger, that has political impact, that does. Now that would, David Peoples is looking at me strongly because he drafted all of our rules of recusal, and I'm not certain I feel that comfortable with it, David, but that's what Justice Christopher is suggesting. I don't think you're ever going to get self-reporting by trial judges on 90-day rulings or timely rulings. There's quite frankly just no uniform case management system in this state, much less a uniform case management docket. They're all local solutions, and the reporting by a judge themselves would be highly suspect as to accuracy. So I just raised that out there. Prisoners are the problem, more so than the litigants. It has been my experience that two motions will be ignored mostly, and that is the summary judgment motion that Justice Christopher and I are familiar with. There are days I pray for page limits and font limits in trial courts. Just give me a 50-page limit and a reason that I can hear a motion to expand a summary judgment past 50 pages and 2,000 exhibits. I would be a happy camper. But that's just a problem. And then the prison font. There is nothing more challenging than reasoning prison font, and it has to be read step after step. And so I think that Frank Gilstrap's suggestion about addressing prisoners might have some, I think it was Frank, might have some merit because they are the ones that don't understand how to get to the coordinators. They don't have the telephone access or the email access to get to the coordinators for the settings. And as a consequence, their emotions can languish. So, but obviously, and I will say that I don't have a clerk present in the 48th District Court when I'm setting motions. And every bit of reporting that you've discussed has a financial impact on a county. This is more personnel on a county payroll. So that would be, and another report through OCA. So just point that out. Thank you.
All right, we got Tom Riney, Nancy Rister, Justice Christopher, and Steve Yalanowski in the queue. And then we'll go back to Bill and have him lay out what he wants us to give him direction on, vote on. Tom Riney.
Thank you, Judge. Well, first of all, with respect to the clerks, I've never seen a clerk in the courtroom in the Panhandle or West Texas, except during voir dire. And many times our judges will have 3 or 4 counties. And so you might have a hearing in a Hemphill County case in Wheeler County. And so of course the Hemphill County clerk may not even have any possible way of knowing that there's hearings been held. And I think we need to break this down into things that have been submitted. The rule talks about being submitted, but some of the comments have been about a hearing never having been requested. Well, in terms of a hearing that never had been requested, it's very easy to separate that between the pro se cases and the cases where there's a lawyer, because lawyers often file motions and don't request a hearing, or they request a hearing and they pull it down because things get worked out. So I don't think getting a hearing is really a problem with lawyers, but if you start running deadlines after the time a motion is filed, you know, it's a separate situation. So perhaps we could have some type of, I know uniform case management is not practical because of the differences among our counties, but at least some kind of best practices where maybe when there is a filing by a pro se, that a clerk does have some type of trigger to warn the judge a certain time after the motion has been filed. But I think we need to be careful about treating motions when lawyers are involved versus these pro se motions, because clearly we don't need, I don't think we need to change the whole system just because of these pro se cases.
Nancy Rister.
Yes, sir. I just wanted to do some FYIs. Our clerks don't go into the courtroom either, but we do all of the OCA reports. No judge does a report at all. And I'm not about, kind of like what Stephen said, I'm not about to tell a judge when or what to do. I'm just not going to do it. That's very inappropriate. I know my place. Now, as a medium-sized county, we do have the software. If a motion is filed electronically, we could set a reminder timer. On a pro se, and it's going to be paper, we can still send it as we scan it in our system and put it in as an event. There is a timer set up in there that we can offer, and we can run reports and let the judge know. But our judge has 3 staff, so the coordinator usually has a lot more time than we do. In smaller counties, some of them don't even use software. Some of them are still on paper, and everything is in paper. They print off the electronic filings, and that would probably be extremely burdensome for them, even though their volume probably is a whole lot less than ours. And as far as these being the inmate cases, that's district court. So misdemeanors, we don't deal with that at all. I don't see it. And we never set the judges' schedules. They have court coordinators that do that, at least in our size county. And I would assume in Harris County too, they have coordinators who set the cases. In smaller counties, I don't know there. I would think that if you've got a district judge who's got several counties, that he would keep up with his own schedule and not depend on all the different clerks in every county. I just kind of wanted to FYI.
Thanks, Nancy. For if you don't recall, Nancy is the county clerk in Williamson County. Justice Christopher.
I didn't mean to suggest that it would be an automatic recusal. I actually meant to suggest that the regional judge could counsel the judge who's not getting their work done. And, if there's a reason why the judge isn't getting their work done, think about moving the cases. And David's probably right. It probably would have to be the local judge to actually move the cases. They'd have to work together to move the cases. But no, I did not want it to be an automatic one. I think what happens with, at least when we're looking at mandamuses, we tend to have the problems with the criminal prisoners rather than the civil prisoners in Harris County, because Harris County's local rule calls for a submission docket. right? But not all district judges have submission dockets, right? So if you want a ruling on something, you either set it for oral hearing or you set it for written submission. And that's pretty clear on our websites. And so a person who's in prison can put their motion on the submission docket and not actually have to come into court and, you know, have a hearing. So we don't tend to have that many civil pro se prisoner problems. We have it on the criminal side because the criminal courts don't have a submission docket. So there's nothing for the criminal prisoners who's trying to get a ruling on something to do to request a hearing other than, you know, file a bunch of letters with the clerk saying, you know, please ask the judge to rule. And of course, then they never have proof that they asked the judge to rule, and you know, it's difficult. So to me, and I don't know, Judge Estevez, whether you all have the submission docket, but that is a very simple way to allow someone who cannot actually come to court and present their motion to, you know, have the motion submitted. And we were, you know, we required 10 days notice. You got to give notice to the other side. But once that's done, it gets on the court's calendar.
Well, they just appear by phone. So we have them appear all the time. So I set up prisoner hearings all the time. So if they ask for a hearing, they get one in person and they appear by phone. So that's not our problem. Our problem isn't that they can't get a hearing. It's that they don't ever really request one, or it's never given to my court coordinator, I guess. I don't know. I don't know what the problem is, but there's a problem.
Steve Yalanowski.
Sorry, I had to unmute. Tom Riney was talking about best practices, and I think that's important here. A lot of times you can't fix things by a rule. And with respect to prisoners, I think there are best practices, and I like what we do in Travis County. And briefly, what that is prisoner communications come in the mail. They don't file electronically. I don't know how it happens, but the clerk's office knows to direct those to the court coordinator, and the court coordinator's practice is then to communicate with the judge about a hearing, some judge, and he has relationships with people in every prison, and he calls that person to prison and says, you know, I need to set up a call with the prisoner for a court hearing, and then that happens. You can't require that of a judge, but it would be nice if judges were educated about doing that. Without that and just having an automatic denial, even if that's what would happen 99% of the time, to me, it's a bad appearance that we're sort of shuttling aside prisoner complaints. I think it does matter how we deal with them, not just how we rule on them. And I think best practices would include something to try to get judges to give them some attention rather than just letting them go away by operation of law. Second thing is whatever we do with regional administrative judges taking cases away from judges, respectfully, Judge Evans, I wouldn't call it recusal, and I'm not sure that you were suggesting that, but that would cross a bright line for me in terms of what we mean by recusal, because it would be requesting a recusal on the basis of something the judge has done or hasn't done in the case. And that to me blurs that quite a bit. I also don't know as a practical matter what it would mean if a judge hasn't ruled on some motion after the case has been in court quite a while. If the case is removed, then does the new judge start over? That's just a question in my mind, but whatever it's decided to be done about it. I wouldn't use the term recusal. That's it.
All right, I said we go to Bill, but we've got two more with their hands up. Judge Estevez.
Well, I didn't want to leave the impression that our inmate cases don't get hearings and that I just deny them the relief they're requesting, because that's not what's happening. As I was trying to state to Justice Christopher, when they file their motions, if they request a hearing, or if they request a hearing at any time and we know about it, we do set it for hearing. We have relationships with our jail, and we've never had a problem not setting a hearing with any, I didn't mean jail, with our prison, and I've never had a problem not setting it for a hearing. So our problem isn't once I've had a hearing that the rulings don't occur. The problems are we've had motions that have been filed and no one's requested a hearing, and I'm unaware that anyone's requested a hearing, and then all of a sudden we've had those motions filed. And I don't know, I can't remember any because I don't have them fresh on my mind to give you specific examples, but we do hear our inmate motions all the time, motions for discovery, motions for mediation. I've ordered mediation in the prisons before, different things that may come up. So
yeah, I heard you say that, and I didn't mean to suggest, I know you said you heard motions. I didn't mean to suggest that you don't. I do think, though, we have to be more proactive with prisoners because they can't pick up the phone. A lawyer can pick up the phone anytime. A pro se litigant can too, even though they may not know where to go. But once a piece of mail hits us from a prisoner, I mean, we talk about sort of some modification of our rules for pro se litigants. Well, take a pro se litigant, put that person in jail, and then what do? If you get correspondence from a prisoner that doesn't ask for a setting, I think we need to be proactive about that because they can't call in, for one thing. For two, they don't know how things work. And so if you get any communication from a prisoner, I think the court coordinator ought to communicate with the judge about that and decide whether it ought to be treated as a request for a hearing.
Well, then I think you need to review that and determine whether that should be a rule for everyone, because that's not what we do. When somebody files a motion with us on any other case, we don't call them and say, set for hearing. If I get a proposed order and it's in my queue and I look at it and I recognize it needs a hearing, then I put set for hearing. But if it's not coming with an order, which is the only way I really know an order's hit my queue, that there's been a motion filed, we don't go looking for those. So unless—
Well, I'm not suggesting a rule. I'm along the lines of best practices. I don't know that, if all the places have considered this, but a best practice, I'm just saying, would be to be a little more proactive, because think about everything lawyers can do, then put that lawyer in a jail and take their phone away.
Levi Benton, then we'll go to Bill. You're muted, Levi. Can't hear you.
Sorry about that. Again, addressing the issue that Stephen raised, recusing a judge in a case because of something he or she did or did not do, which is why I find more appealing saying to the judge, you may not be assigned any more cases until you address this. In the small counties, let's say it's a one judge county, the commissioners or the Supreme Court would have to assign another judge temporarily to hear the cases, the new cases, because the judge that's behind can't take the new cases. And so taxpayers grumble, hey, judge, do your job so we don't have to pay for the second judge. In a multi-judge county, then you have the peer pressure of, hey, it's not fair. I'm getting more cases because you're not doing your job. And so I just want to lay that out there one more time to Bill and the subcommittee, because I really thought others would bite on that brilliant idea of mine, but no one did. And then finally, the beauty of this committee is that you always find out about the diversity of this state. In the 10 years that I served on the district bench, I think there was hardly not a day I went into the courtroom to hear arguments where there wasn't an assistant district clerk in the courtroom. Interesting that others don't have that practice.
All right, Bill, what can we do to give you and the subcommittee guidance?
So I think let me make sure I'm unmuted. Yes, I am unmuted. I think I've got a decision tree here that I'll ask for votes, I guess. Let me sketch it out if I may, and then we can refine it as needed.
Right.
The genesis of this topic, I think, was prisoners seeking rulings in all cases, both civil prisoner cases and criminal prisoner cases. So I can see a first decision vote being, do we want to, whatever our approach is, do we want to limit it to prisoner cases involving civil matters, or do we want to try to bite off civil cases generally? That would be step one. Step two, a vote or guidance on whether we have a reporting only approach, a notice of ruling needed approach, or a combination of both of them together. And then step three would be guidance about whether we want to involve the regional presiding judges in some way to be determined, because there's obviously a lot of very thoughtful and important considerations that go into that. So I sort of see that as step one, step two, and step three.
All right, so on step one, the question is, should we limit whatever we do to civil cases involving prisoner cases that are civil, not on the criminal side? So yes, we would limit it to that. No, we would look at the other issues that we've talked about this afternoon. So if you think yes, I think you hold up your hand. I believe is the way it happens. Then we can count them.
Judge, there's a way to raise your hand electronically for the participants down in the bottom right of the participant list. So you'll actually be able to see that.
And Chief, this is Lisa Hobbs. Could I just get a clarification on the vote?
Yes.
Which is, are you saying if we want to include prisoner cases, are we limiting them to civil only and not trying to go into the foray of the criminal side? Or are you saying the subcommittee's task should be limited only to civil inmate cases and not whatever the problem is on getting rulings in general?
I think the latter, right, Bill? Or not?
That is correct. So by asking for this vote, I'm excluding all criminal stuff completely. And so all criminal matters completely. And so the vote would be whatever rule or approach we use, are we addressing only civil cases involving prisoners, or are we addressing civil cases generally? That's what I'm trying to drill down to.
Great. Thank you for the clarification.
Yep. So vote if you haven't, please. Let's see, 4, 6, 8. Okay, 2, 4, 6, 8, 10, 12, 14 looks like to limit. And now if you'll pull your hands down. And people who think we should look at the issue more broadly in other kinds of civil cases, now raise your hands.
I changed my vote because I didn't quite understand it the first time. I'm sorry.
Okay.
So take me off the first one and put me on the second one.
All right. So that's 11. 13 to 11 is what I show. And then the second issue Bill wants some direction on is whether the mechanism, the correction mechanism, should be reporting only or separately giving notice the ruling is needed or both. So I guess the way to vote on that is just everybody who thinks it should be reporting only or both vote that way, and everybody who thinks it should be notice of a ruling needed or both. Is that right? I'm not sure that's right. No, that's not right. Pam's shaking her head. All right. Let's just vote on the three of them. Reporting only, notice of a ruling needed, and then we'll vote on both. So first is reporting only. Hold up your hand, please. That has, everybody voted? That has one. Then notice of ruling needed.
Chief, I'm sorry to interrupt, but it looks like Richard had his hand raised, so I couldn't tell if it was for the first vote or for the second vote.
Richard? Second one, I think.
It's going to be for the third vote, not for the first vote. It's for both. I like both. So don't count me as report only.
Okay. That's 13. No, let's see. Yeah, 13. And then both. So take your hands down and vote for both. Two, four, six, 2, 4, 6, 7. So that looks like 7. Oh, so there's 1 for reporting only, 13 for filing a notice of ruling needed, 7 for both. Bill, that's my count. And then the third thing Bill wants guidance on is whether we should ask the regional presiding judges, there are 11 of them around the state, whether they should be involved in this by counseling the judge, assigning cases, getting somebody else to reassign the case, or how should the regional presiding judges be helping to monitor this? And we have 2 on the committee, and I think 2 no votes. But if you think yes, we'll see in a minute. If you think yes, please.
Can I ask a question? They already have the obligation to monitor this. It's in the comment. Regional presiding judges shall determine the existence of cases tried and awaiting entry of judgment. Been there for 20 years. So what has this different?
Bill?
I guess what we're contemplating is the discussion that's occurred about whether there should be some additional affirmative steps that the presiding judge should take. Counseling, shifting cases, other, to be discussed if we go down this path.
Which if I can just say, and Judge Peoples, you obviously know your job better than I know your job, but I certainly have a hand in it. I think you can transfer case. I think you can certainly go to your judges already and say, hey, we've noticed some mandamus proceedings being filed. What's going on? What can we do to support you? I think you can either even transfer cases with or without the local administrative judges thing. I think the regional PJs may be able to transfer at least individual cases. I'm not sure you could say don't assign any more cases to them, but you could, if there's some complicated cases that we're just not getting rulings on, I think you could intervene. But maybe we have sort of assumed some of that in our discussion. And Justice Hecht, I'm sorry if I'm opening the floor for discussion after the call for the vote, but I mean, what do you think a regional PJ? Some of this isn't just giving you authority. In other words, what I think is it's giving you sort of extra permission to do what you already have authority to do.
I don't think a regional PJ has the authority to take a case away from a judge who doesn't want to give up that case. Now, recusal is different. We're not talking about recusal here.
No, but what about transfers? I mean, y'all take cases. I mean, presumably when you get a request to transfer a case, you do it without necessarily the consent of the trial judge.
No, those are after we've had hearings on a recusal.
No. Justice People, I'm talking about outside of the recusal. So I'm thinking about like, I'm kind of thinking about maybe Rule 11, and so maybe I'm getting confused, and then ultimately Rule 13.
Okay, MDL is totally different, Lisa, but I just don't think there's anything in the statutes that lets a regional PJ take a case or more away from a judge who doesn't want to give up that case.
Okay, so you couldn't think for the efficient administration of your region that you could pop into some case in Bexar County and say, no, I think it actually should be in, I forget your region, but it could be in Bernie or wherever, whatever county that is. Outside of Rule 11 or Rule 13.
I'm not aware of it.
Okay, I misunderstood. I thought y'all could actually transfer cases more easily, but maybe I'm just misremembering the statute.
David Evans, you aware of anything like that?
He's on a personal emergency,
okay.
So he's not on right now.
Judge Peoples, one more question. What about within Bexar County? If you saw a problem, so you're not dealing with statutory or constitutional restrictions on where a case can be filed or heard, but you wouldn't intervene and move a case from a judge, even within the jurisdictional parameters of the original filing of the case.
I think that is a correct statement.
Okay. So then I think as we answer this question, I think one of the things, it would be easier to move it to somebody within the same county, but I think we should all remember it would only be by statute or constitutional change that they can move it outside of the county for sure.
All right, so I show 8 for extending the involvement of the regional presiding judges. If you would put your hands down.
Hey, Chief, will you make that 9? Because I was talking instead of voting.
Yep.
So thank you.
Yep.
And please. I was listening.
11, I'm sorry, I didn't know. I didn't realize we were calling the vote when the discussion was open. So this is Kenan and I'm on board too.
Make it 12.
All right.
Chief, should we just redo that vote? Because I think there are a lot of everybody put their hands down and redo it one more time so we have an accurate vote.
All right. Let's vote again for involving the regional presiding judges. Yes. Hands up, please.
Well, I think we can always be involved, but this is for involving them to a greater extent, correct?
Yes.
Show 15.
16.
16.
Oh,
2, 4, 6. Now 14 now.
Chief, I took my hand down after the vote, after you said the count. Sorry.
I did the same thing, Mrs. Kinnon, but I put it back up.
I got 18. 2, 4, 6, 8, 10, 17. Okay. And then for not, put hands for doing it down, hands for not doing it up.
And Judge Evans did give me his proxy to vote, so he's voting on in this vote.
Justice Hack, I think the host can just clear out the hands just to make sure in case
Pauline
somebody's
maybe.
forgotten to lower their hand.
Okay, Pauline may be.
Oh, well, she just cleared me out. Let me.
So the nots are 4. So that's a good clear vote. Oh, 5.
And so for my clarification, Chief, when we go back to the first vote, which I think you said was 13 to 11.
Yes.
That means 13 in favor of dealing of confining whatever rule proposal we come up with to prisoner cases only involving civil matters. Is that correct?
Yes.
Okay. All right.
What I understood, yes. Okay. Anything else that you need guidance on, Bill? Or this?
No, I think that gives us the ammunition to take another swing at it.
Okay. Well, then that takes us to the last item on the agenda, which we should be able to finish without too much trouble. So maybe we should go ahead and take a little break. And I've got 2:45. We have a visitor, Municipal Judge Ryan Henry is with us. So let's come back in 10 minutes, 5 minutes to 3, and finish up.
and Chief, I'm back if you want to relinquish the reins, but you
Yes.
sound like you're having fun.
No, I wouldn't call it that, but good to get back.
I mean, I've never heard so many votes. It was awesome.
So we'll take a 10-minute break.